Town Community Television, your hometown news and information station.
Welcome back. I'm Vincent Perryman, and you're watching Legalese. Joining us on our show is Bill Jones of the Jones Law Firm. We were discussing post-divorce litigation. Bill, before the break, we had covered sort of the parenting plans and how to modify those. The next big issue post-divorce is child support and how that, when that ends, and if it can be modified, and sort of what it would be indicia that you could go in and modify it.
Sure. You can download a child support calculator. I think you can go to tn.gov and download a child support calculator. You can find one on our website, midsouthddivorce.com. Both places I've found, I'm amazed. My clients know how to work these calculators backwards and forwards. But you can go in there and you can enter information and see whether or not a change in either your income or your spouse's income would entitle you to an upward or downward modification of your child support. And that's going to be something that you want to check yearly. Most divorce decrees say that you are supposed to exchange W-2 or tax return information with your former spouse. I think it's by the 15th of, I want to say March each year. So you provide them with a copy of that. Then you can go in and run the calculations. What you're looking for is a 15% change, either upwards or downward. And if you reach that criteria, then you can ask the court to modify your child support. The big question that we get on child support is, when does it end? There are a lot of folks out there that give legal advice that just aren't attorneys. And I think there are a lot of misconceptions going around. Child support is going to end when the child turns 18, or when the child graduates from high school, or when that child's class should have graduated from high school. So if the child turns 18 in January and is still a senior, child support doesn't end when the child's 18 in January. It ends when he graduates from high school. Sometimes child support can go on past the age of 18, but generally that's because there's a medical need. There's a child with a special needs, with some type of impairment, where they will always need that support, where they won't ever be allowed to provide for themselves. When it comes to child support, I've had mother and father after mother and father in my office saying, I don't want their money, I don't need their money. And I always tell them, it's not your money. It's to be used for the benefit of the child. So make sure that you're looking to see if it should be modified, and if it is, pursue that. If you don't want the money, put it in a savings account. When they get ready to go to college, when they need a car, you got the money. So make sure that you're pursuing that and that you're looking at. That's just a numbers game. There's not a whole lot of argument to it as far as modifying child support. If a spouse is trying to hide income, it may become an argument then. But if both parties are being upfront with each other about what their income is, then it's really just as straightforward as putting these numbers into the calculator and seeing what it is. Aside from child support, the other big area that we get into is just modifying other portions of the divorce decree that don't have anything to do with the children or with child support. And all our office really handles is bankruptcy and divorce. Outside of that area, and this is a question for you, are there any other decrees that you see normally altered or amended by the court?
Well, the only thing on that would be is if somebody's doing collection action and you've got some reason to alter a payment plan.
Yeah.
One that I've seen numerous times here recently with all this foreclosure stuff is divorces where there was a marital home or a rental home that was marital property, and it was put on the market. They can't sell it because they're upside down on the mortgage. things like that.
But divorce is one of those
Yeah.
creatures that is a little bit different in the law, where it's never really dead. It's never really final. We have folks come in and say, my job's changed, my career's changed, I need to modify this term, I need to modify this term. And generally, you're going to be talking about either we forgot something. I forgot that I wanted my grandmother's antique clock, and we didn't put that in the decree. So we'll go back and ask to modify it. Or there's been a material change in circumstance. I've lost my job. I know that he got a promotion. He won the lottery. Something has changed.
He quit being an attorney and started doing woodworking.
He quit, and that's the case that everyone talks about, where the doctor quit being a doctor and decided he wanted to make furniture in a shed, and the court said that doesn't make your alimony payment go down. It stays what it is. But that's the big area that we see. It's, I've lost my job, something's happened, and I need to modify my alimony. Now, depending upon how your divorce document is written, you may or you may not be able to go in and modify that. And that's troubling. But, well, I guess it's troubling depending upon which side you're on.
Right.
You're going to have to show, in order to attempt to modify it, that there has been a material change in circumstances, that something is now prohibiting you from either paying this alimony, or that this spouse no longer needs this alimony. It's very important that you read these documents with a fine tooth, because not all alimony ends on death or on remarriage, or can even be modified.
Yeah, the alimony thing is just, and then when you get in the tax ramifications back and forth with it is a big one. When we return from our break, we'll talk more with Bill Jones about post-divorce litigation. Please stay with us.